Thank you. Thank you. Our next speaker is going to be James Willis with Daly in Black. James Willis. Can we get his mic on, please?
Oh, wow, that's cool.
Yeah. I'll get that reset.
Oh, wow, that's bright. Can y'all hear me? Hey, Cheryl. What's that? What does that do? Oh, the clicker? Okay. Hey, I'll introduce myself in a moment. I'm probably a fresh face to most of you. But back to the issue, and by the way, in the morning, I'm mediating with Cheryl O'Brien. And if I could reiterate from a plaintiff's perspective about walking into a mediation and people being concerned that it's too chummy, if that makes you uncomfortable, let me just say this. The most difficult cases that maybe I didn't expect to settled because people were being respectful and somewhat chummy to one another. I mean, I found that you can litigate through scorched earth. Am I done too? Well, that was quick. You can litigate through scorched earth, and nothing gets accomplished. People get prideful. But on both sides of the docket, at the end of the day, we're human, and honey gets a lot of things done that scorched earth wouldn't have gotten done. And so if you walk into a mediation and people are being friendly and chummy, I guarantee you they're being respectful. And that's one thing I love about mediating with Cheryl. And why would I, as a plaintiff's lawyer, ever want somebody who was a defense lawyer forever to be my mediator, my go-to mediator often? Because when she walks in the other room with the insurance company, Cheryl speaks insurance. I don't. I speak policyholder. I'm looking through my own colored glasses all the time. And she knows exactly what to say to them in the other room. So I just wanted to offer that perspective from a plaintiff's lawyer. I can't remember who had the question. Anyways, I'm likely a fresh face to most of you. Y'all probably know my law firm, Daly & Black. My name is James Willis. I'm a shareholder there. I've been with the firm for close to 6 years. So Rick and John, you've probably met them or you've seen them speak, London Crounce. I came here today because I asked to be here. Usually these guys keep me in a cave. I'm at mediation in the courtroom taking depositions. I am the grunt. But I wanted to be here because I've seen what Cal is trying to do, right? I follow him on social media. I knew that this would be educational, and I wanted to come and nerd out. And what I'm going to nerd out about today is something I know you've probably heard way too much about. Everyone wants to talk about bad faith. And I'm going to do that, but I don't want to repeat what anyone else has said. I want to talk to you about it from a historical perspective, because I get phone calls all the time from a contractor, a public adjuster, who says, dude, I got a bad faith case. And then they reiterate the facts to me, and I say, dude, that ain't bad faith, right? And then they think I'm against them or something. And one thing I've found, if you follow the history of bad faith, you learn a lot about it. How did it develop in the United States, not just in Texas? And the other thing you learn is that it's actually a really dramatic story. The 4th of July is coming up, okay? And I know what we celebrate on the 4th of July. We eat hot dogs and hamburgers, and we celebrate the right to bear arms. At least half the room probably does. Everything that makes us proud to be Americans. But one thing, I kill 4th of July parties when I say, and we have bad faith, right? Nobody seems to think that's American, but it is uniquely American. There is something similar in Canada and some other common law countries, the United Kingdom. They're far more dramatic in what they call it, but it's, I think, the duty of utmost good faith, right? I could just see someone with a barrister wig and British accent saying that. But we call it the duty of good faith and fair dealing, and it's uniquely American. So I want to talk about how we get there. I put the clicker down. Green button, right? Okay. So this dramatic story actually goes back to 1868, and most commentators on this, they agree that this is the case that gave rise to bad faith in the United States, and it's quite dramatic. So what happened was the state of Virginia realized they had a problem, and it's a problem that we can imagine happening today, and maybe does. Out-of-state insurance companies back then were selling fire policies and crop insurance, life insurance, and when it came time to collect for the person who paid the premium, they wouldn't pay up. And there was no recourse for them back there. I mean, what were you going to do with a Delaware insurance company if you lived in Virginia? Were you going to hail them into court in Virginia, make them get on a steam train or a ship and come down to Virginia? You had no recourse. And so the states were starting to get frustrated. And they said, you know what? Congress, we need you to do something about it. Congress wouldn't do anything about it. So the Commonwealth of Virginia, passed their own regulation, and it said two things. If you are an out-of-state insurance company from New York, Vermont, wherever, if you're going to sell a policy here, you have to obtain a license and you have to pay a bond. So one guy got cute, okay? After they passed that, a resident, a citizen of the Commonwealth of Virginia, got a very lucrative offer from a New York insurance company that said, dude, we've talked to our lawyers. That Virginia law, it doesn't fly under the US Constitution. Only Congress can regulate this. The states can't regulate this. And so Samuel Paul got cute, and he started walking around Virginia selling policies to people in Virginia from an underwriter in the state of New York. Okay, so you can imagine that the Commonwealth of Virginia had a problem with that. And so guess what happened? Samuel Paul got busted. And I've always wondered how this played out when, he got arrested, I guess, and went to jail. And it's like, what are you in for? Well, I was selling out-of-state indemnity contracts, So what really happened was he got a $50 fine, which back then I imagine was a substantial amount of money. But the company in New York had been just waiting to pounce on this. They've been looking for the test case. And they said, all right, we're going to file a lawsuit on it. It went to the Virginia Supreme Court. Virginia Supreme Court sided with the state of Virginia. Not a surprise. Then it went all the way to the US Supreme Court. And he was making a constitutional argument, okay? And basically, ignore the quote up there. It really came down to this. Is the selling of insurance, is it commerce across state lines? Because if it's commerce across state lines, that means only Congress can regulate this. And the Commonwealth of Virginia can't. So I keep pushing the wrong button. All right, and here's what the court said. They basically said, look, this is not interstate commerce. It's not as though you're bundling up a freight of insurance contracts, putting them on a steam train, and sending them across lines. You might draft the contract in New York, but you're ultimately sending it to the state of Virginia, and it's not a contract until the premium is paid and somebody has signed it down there, the policyholder. So basically, the Supreme Court was giving a license to the states to regulate this. And they realized the drama behind it. If you read kind of the history on this case, you probably got better things to do. But the US Supreme Court was well aware that there was a real problem in the United States because Virginia was not the only state that was having problems. Other states were starting to recognize Congress isn't doing anything. We got people paying premiums to the rich coffers of these companies, and they have no recourse. And so the US Supreme Court, I think, realized, look, Congress, if you're not going to do anything about it, states' rights, let's let them do it. Okay, so the green light was there for the states to regulate insurance practices, to come up with an insurance code or bad faith, and nothing really changed. Sure, in most states you had to have a license, you had to put a bond up, but 80 years later, the US Supreme Court had to take this issue up again, because this time Congress did want to regulate insurance companies through antitrust laws and through applying some kind of tax. To be honest, I didn't understand what they were trying to do, but it went to the US Supreme Court again. And I love this quote here, because before you read it, let me say this. We'll be sitting around having drinks, public adjusters, policyholder attorneys, and you always hear this, or contractors say this, boy, the insurance companies have gotten really bad the last 10 years, right? I mean, almost as if in the good old days, they were paying claims left and right. And that's not true. Here in this quote, the US Supreme Court is talking about the Samuel Paul opinion. And they're talking about how, I mean, look at the very end. As early as 1866, the insurance trade, though still in its infancy, was subject to widespread abuse. I mean, it was happening then, in its infancy, right at the beginning. And so what the court ultimately held is, okay, Congress, we pull that back a little bit, what we said 80 years ago. You can regulate a little bit, but you still can't regulate everything. So the very next year, Congress passes an act, and the point of the act was to encourage states to get their act together and start passing insurance codes. And some of them started to. They tried to encourage them to do it. There was some way they pressured them to do it within 3 years. Okay, but it still wasn't enough, because in the courtroom, if you were to sue an insurance company, maybe the best you could get was your contract damages, what they owed you under the policy. Maybe you could get interest. But there was no separate cause of action for what we today call bad faith. And the courts in California started to recognize this was a problem. And most people trace it back to the Colorado Supreme Court. And they defined this other cause of action not in contract, but in tort, where, okay, when the facts show that they clearly knew better, or later, about 20 years later, they broadened it to say, okay, when the facts show that they just turned a blind eye and did an unreasonable investigation, you don't have to recover only through a breach of contract through the policy. You can also recover under tort. Other states realized this is working. This is pulling in the insurance companies and giving them an incentive to actually pay up on the claim. And if y'all ever have a chance, and you know, you're going to call someone and say, dude, I got a bad faith case, I guarantee you, you don't have a bad faith case like the Arnold case. Has anybody ever read this? Just a quick show of hands. Yeah, I know you have, but you don't count. Read this case. I mean, these are some jaw-dropping facts of what happened. And in a nutshell, guy gets into a horrible motorcycle accident. The independent adjusting firm that was handling the claim told the carrier, the underwriter, dude, you owe for this. And they still just wouldn't pay it. And then this whole thing about fraud and the FBI having to get involved later on, I don't think that's in the opinion, but it's really dramatic. And that was enough for the Texas Supreme Court to say, okay, we've had enough. There is a special relationship between a policyholder and an insurance company. And here's why. An insurance company has exclusive control over the evaluation, processing, and denial of claims. Everybody here would agree that's true, right? Little old lady calls in a claim to Allstate. Sure, she could hire a public adjuster, but at the end of the day, Allstate is the one who decides whether they perform or not. And they noted, without such a cause of action, insurers can arbitrarily deny coverage and delay payment of a claim with no more penalty. It only took the Texas courts over 100 years to figure that out. Wish I could go back in time and tell them back then, dude, just get it done now. So, there are two causes of action. There's tort and there's contract. And if you don't know the distinction, just understand it like this. It all has to do with where your duty to do a certain thing comes from. So we might have a contract with one another. Alex and I here might have a contract that I'm going to sell him 100 widgets for $100, right? So my duty is to give him widgets. His is to give me money. Outside the four corners of that contract, we don't owe each other anything, except under a tort cause of action. You don't need a contract. This is just what reasonable people should do towards one another. And the Texas Insurance Code defines what that is. It says if you are engaged in the business of insurance, this is basically what you have to do as a reasonable person, regardless of the contract. So I wanted to talk to you all about what a jury charge actually looks like. Many public adjusters and contractors, they've never seen one, and I think it's very helpful if you understand the questions that are going to be asked of the jury in the courtroom. You might start to see bad faith differently. Bad faith doesn't exist unless the jury says yes to those questions. So the first question that's generally asked is just about the breach of contract. Did Big Bad Insurance Company fail to comply with the insurance policy agreement? Can y'all tell I'm biased? I write these, Big Bad Insurance Company. So basically, the jury is just asked, there at the bottom, yes or no. They're given some instructions. And question 2, what sum of money, if any, if paid now in cash, would fairly and reasonably compensate the policyholder for his damages? That's simple. Question 1, did they breach the policy? Question 2, how much? So bad faith hasn't come up yet. That's the contract cause of action. Question 3 is where the bad faith begins to be asked of the jury. So did Big Bad Insurance Company engage in any unfair or deceptive acts it should be, or practices that could cause damage to the policyholder? And they're instructed on what an unfair or deceptive act or practice means. And y'all might recognize some of this stuff. It's from Section 541 of the Insurance Code. So it could be refusing to pay a claim without conducting a reasonable investigation, a misrepresentation to the policyholder, failing to attempt in good faith to effectuate a prompt, fair, and equitable settlement of the claim, failing to affirm or deny coverage within a reasonable time. And you'll notice on the second to last one, I accidentally left State Farm in there. Guess I didn't do that word search. Anyways, they answer yes or no, okay, on this. So did they commit any of those things? The next question is repetitive of question 2. What sum of money, if any, if paid now in cash, would fairly and reasonably compensate the policyholder for his damages? And some of you might be thinking right now, well hold on a minute. What about treble damages? Because I get those phone calls all the time. Dude, I got bad faith. They didn't pay my O&P. Let's get treble damages, right? It's not that simple. The first element of damages under bad faith is just the policy benefits. Under a bad faith theory, in tort, you can recover what you were owed under the policy. And you have an election of remedies as a policyholder. You can either recover under the contract theory, or you can recover under the bad faith theory. But now, the issue of treble damages, as we hear it, comes up. It's not enough for an insurance company to have just committed bad faith. They had to have knowingly committed bad faith. And I know, for example, Cheryl runs into this all the time at mediation. She hears it all the time. Dude, I got bad faith. She's probably heard it out of my mouth with a lot of bluster before. And she knows that I know better, because I don't necessarily have that smoking gun email, right, where the insurance adjuster is saying, like in the Arnold case, nah, we ain't paying it. We know we're liable, but we're not paying it, right? That's what it takes. And so the thumbnail approach to bad faith and treble damages before you call the policyholder attorney or before you advise the policyholder that you've got a bad faith case is you need to ask yourself, if I'm going to make a claim for treble damages, do I have evidence that they knew they were liable and they just didn't do it? Did they know that they were conducting an unreasonable investigation? Did they know that they were misrepresenting the policy? Did they know that they were failing to effectuate a prompt, fair, and equitable settlement of the claim? So, if they answer yes, then we get into the treble damages question. And it's not automatically treble damages. The jury is allowed to award up to 2 times more the amount of what the policy benefits were. But they're asked to, I left State Farm in there again, my bad. The nature of the wrong, the character of the conduct involved, the degree of State Farm, Big Bad Insurance Company's culpability, those types of things. It's only then that you get to this idea of treble damages. So, how do you get the jury to say yes? First, you have to get past the gatekeeper, the judge. If you file an insurance claim and then you take it to court and it's an out-of-state insurance company, 99 out of 100 times the insurance company is going to remove to federal court. And why do they do that? Because they know federal judges are acting as the gatekeeper on bad faith. They know that it's not enough to say, well, they didn't pay O&P, right? That desk adjuster didn't call me back. That's not bad faith. You have to have something that shows that they were unreasonable and perhaps knowingly unreasonable. Federal judges throw these things out all the time. Cheryl and I were talking about a case recently with another plaintiff's attorney, where in the Eastern District of Texas recently, Judge Jordan threw out somebody's bad faith cause of action because State Farm had inspected the property 3 times. Just said, well, that's reasonable as a matter of law, okay? So you got to get past the judge. You have to have that smoking gun email or something to lead to a strong inference that they knew and they were just ignoring it. So bad faith is not the phone call where someone says, dude, they didn't pay my O&P. They ignored my helmet. Well, so what? People are allowed to have reasonable disagreements. Dude, I gave them a letter from DECRA saying the tile is discontinued. That's not bad faith either. You got to have something more than that. And the last one, which I had to kind of bleep out, dude, that adjuster is a you-know-what. That's not enough either. Now, that might help on the witness stand later. If I can get under his skin, make him appear that way, juries hate that, but just being a bully is not enough. Someone can be very nice, look you in the eye, and commit bad faith knowingly too. So what is bad faith? Here's the thumbnail approach, and this came from the Arnold opinion. Where there is no reasonable basis for denial of a claim or delay in payment or a failure on the part of the insurer to determine whether there is any reasonable basis for the denial or delay. Focus on the reasonableness of it. Did they know? Was it completely unreasonable? If you were in their shoes, would you have done the same thing? And can you prove that they knew that they weren't doing the right thing? So I want to walk you through, you know how much time I have left? Oh, yeah, well, I don't want to get cut off by the fire alarm. Made me think, oh, we got a claim, fire alarm. Okay, so I want to talk to you about how some of the Texas courts of appeals have started upholding verdicts, okay? And I've found the best path to get there, it seems, is to prove that they conducted an unreasonable investigation. So this was one of our cases. It was a cosmetic exclusion. We were allowed by the Court of Appeals to recover our policy benefits under a bad faith theory. And there were many more facts, but these are some of the themes that I've seen coming up in the courts of appeals. First, where an insurance company refuses to inspect something. In this case, it was the interior. The insured wanted the adjuster to come in. He said, no, I don't really need to. Turned out that was material to a claim for a metal roof involving a cosmetic damage, particularly when coverage is triggered because the roof is leaking. Wouldn't you, as a reasonable person, in that adjuster's shoes, think that you need to go in and look to see if water is leaking? Sounds unreasonable to me. And it's hard for them to say that they didn't know that that would have been reasonable. So the insured asked for a reinspection, and this is what they told him. We'll reinspect, but the second guy isn't going to find anything new. Okay. That's a good fact to put in front of a jury to show that they were denying the claim without conducting a reasonable investigation. Also, Allstate, and I can say this because it's now a matter of public record, I can say this now because the Court of Appeals called them out on it. Your own claims handling guidelines said that you were supposed to send out an engineer to investigate that metal roof if the insured disagrees. And Allstate didn't do it. They just ignored that, had no answer for it at trial. So, failure to conduct a reasonable investigation. I think this was one of Mostyn's cases. And we see the same trend in the Court of Appeals. I love reading this case, by the way. If you haven't, go read it. It's a good one. Okay. It's because I really don't like AllCat, all right? But they call AllCat. I mean, the Court of Appeals just mopped the floor with AllCat. Okay, and some of the facts they pointed to that supported a bad faith finding was AllCat only inspected the lower slope of the roof. Much like in the Reininger Allstate case, they didn't inspect something that it would have been reasonable to inspect, and they just refused to do it. The engineer did not even step on the roof. He was one of those guys that said, I'm too old for this, got up on the edge of the ladder and said, I'm not doing it. They used 6-foot by 10-foot test squares. Where'd that come from? I don't know. I'm a lawyer, not a roofer. Has anybody heard of a 6 by 10 test square? Exactly. Allcat used a price list that predated the storm. Pretty unreasonable. And this was my favorite that the Court of Appeals pointed to. Mind you, they had evidence of baseball-sized hail. And the engineer that USAA sent out said that the baseball-sized hole in the insured's pockmarked satellite dish was caused by a baseball rather than hail. And you laugh, I wasn't there, but I'm sure that probably got a chuckle from someone else in the courtroom, maybe the jury. Unreasonable. I don't know whose case this was, but this is a good one as well. State Farm versus Vega. Again, the Corpus Christi Court of Appeals. And they say the jury heard evidence that Sylvia only inspected certain areas of the house and that Sylvia did not inspect the attic. Are you seeing a trend here? You didn't inspect something that a reasonable person would have done. The jury could have reasonably found that it was State Farm's duty to properly inspect the Vega's house for damage and not Myra's duty as a layperson to know where the leak originated. That came up in the Reininger case as well. The insurance company says, well, they could have told us there were leaks. But the court recognized, no, at the end of the day, insurance company, you're engaged in the business of insurance. You're the professional. You're the one who has the reasonable obligation to go and look at it and find it. The insureds don't necessarily know this. Okay, so that's it. I guess the alarm didn't go off yet. I hope that what I've given you some insight into is what a jury charge will look like. If you think you see it out there and you anticipate a case is going to go to litigation, you have to start thinking about it out in the field. What can I do now that is going to show a jury later on and help that policyholder attorney out when he has to put evidence in front of the jury? What can I do now? Tomorrow, I'm speaking again at 1 o'clock, and I'm going to show you those things. Things I haven't come up with, things I've learned from PAs, okay, that have shown me, like, hey, that really worked. And not only that, that's admissible in court. That's my smoking gun there, to show that the insurance company knew that they were conducting an unreasonable investigation. They knew it because this PA documented it correctly. I'm also going to be talking to you about cosmetic damage exclusions. That's one of my favorite issues. Insurance law can get dramatic. I'm not much fun at parties, okay? But I believe it can, and I believe it can be academically interesting, and that is one of my favorite issues, and I'm going to talk to you about something I see developing here on how cosmetic damage exclusions can help us prove bad faith in the courtroom. We're also going to talk about the rules of evidence just a little bit. I think out there in the field, you need to start thinking about what constitutes hearsay. It doesn't do the jury any good if they don't get the evidence later on, if they can't see it because it's excluded under the rules of evidence. And that is particularly true with respect to storm data. There's some storm data that you can get in front of a jury later when they're all glazed over after the 5th day of trial. If you put a bunch of bright colors in front of them on a NOAA map that is admissible in court, they've got something to look at, bright colors at least. But when the insurance companies continue to rely on core logic and all these other things that tell them what they want to hear, guess what? Those things don't come in, not into evidence. At best, the expert can just say what he saw in a core logic report. But you're showing them the bright colored NOAA SPC map that shows all these storm spotters, telling them exactly how big the hail was. Okay? So if anybody would like to get to know me better, I promise I'm a lot of fun at parties talking about insurance. Or if you have questions, you just want to nerd out, here's my email address. I appreciate you guys, Mr. Spoon, Sean. Thank you so much for having me.
Looks like we have one question over here.
Oh yeah, I forgot. Someone else might want to talk.
Here you go, sir.
I was just curious,
Wait, I'm
over here, to your left.
Oh, there you are.
I was just curious, you mentioned on there, and I've seen this several times where the homeowner will say, well, he didn't even go up on my roof, or he never even came inside. What's to stop the carrier from saying, oh, well, they're independent. We don't know what they're doing. We had no idea what they did. Is that bad faith? Are they still liable for that?
Yeah, they are. I'm not aware of any way that an insurance company can send out, and you mean they sent out an independent adjuster?
Yeah, but they were saying that, that they didn't intend to do that. That person did that on their own. They weren't, as a carrier, doing that intentionally. See what I'm saying?
Right, and that's a really good question. So let's say it's not an in-house State Farm adjuster and they hire someone else. Well, by that point in litigation, under the new, and assuming it's a storm claim, okay, under 542A of the insurance code, you're going to get a letter from State Farm or the other carrier at the end of the notice period, the pre-suit notice period, that says, we accept responsibility for, whoever was out there on the risk, right? And even if they didn't, it's hard for them to say that this was reasonable regardless, okay? Maybe they say they didn't intend to do it, okay? But you might have evidence there that they certainly didn't ask. I mean, wouldn't it have been reasonable to ask your guy who's telling you what the damage was, hey, did you go up on the roof? Let me get that. But it's my alarm, not a phone call.
We got one more question, then we're going to move on to our next speaker.
I hope that answered your question, by the way.
Yes, sir. Over here.
Yeah.
You spoke a little bit about bad faith in regards to delaying and denying. How about when it comes to severe underpayment, for example, Lake Charles hurricane, they offered $20,000 for the whole home, and even when it goes to appraisal, even the appraisal panel agrees this was the $200,000 damage. Like how is that? Is bad faith being won on that type of
just on an underpayment?
Severe underpayment. Is there such thing as severe, and what does that look like?
Yeah, yes, it can be bad faith, okay? The courts tend to think it's not, if we're talking about a $5,000 to $10,000 difference, okay? But you brought up appraisal, okay? And this is something that I wish Texas courts would get right, and I think they're wrong about it. In Texas, you can't use the difference between the appraisal award and the breach of contract as evidence of bad faith. The reason is because your bad faith claim is gone post-appraisal. But other courts have recognized this. The 10th Circuit federal court has recognized that that's evidence. How is it that this appraisal panel came up with $200,000 and you, Allstate, had $2,000? That's probative. Courts in Colorado, we have a Denver office. The Court of Appeals there has recognized that as well. That can be evidence. Okay, so it depends on the nature of the difference in payment, but also within the difference of that payment, ask yourself the same questions. Was there something unreasonable that they did? I mean, were they at $2,000 when it was really $200,000 because they didn't look in the attic? Something along those lines. Yeah. Yeah, and that came up in the USAA one I showed you, because the poor all-cat adjuster, overworked, sleeping out of a car in a cat claim, is just told to go from one below deductible to the next. Too many claims in a day, not enough training? Absolutely. Right. Is it unreasonable to hire a guy who last week was dealing cards and had never seen a roof before to adjust claims? Absolutely, that's unreasonable. Yeah, exactly. Right. Yeah, exactly. They don't want somebody who's going to push back on them. Well, I'm going to get on a soapbox. This is supposed to be educational. I'm supposed to be unbiased. Big bad insurance company. All right, I really appreciate y'all. Anybody else? Oh,
Absolutely.
yeah, we have a booth. Yeah, that thing for marketing downstairs. Come say hi. Otherwise, I really appreciate y'all letting me nerd out with you. Thanks for letting me get out from behind my desk, and hopefully I'll see you tomorrow, 1 o'clock.
What's that? I think it's just 9 a.m. Whenever there's not a set time.